Several weeks ago, social media companies in California lost a tort and negligence action against them based on human rights, based on torts principles. And my question for us today is, are we there yet with environmental rights? Are we there yet with the right to a healthy environment? I am a litigator, I am a rights lawyer, I am an environmental lawyer, and I want to walk into court with an environmental right, and I want to say, this is in our Constitution, and I want that vindicated for every citizen, and I want to be able to have a tool that I can walk into court and bring not just judicial reviews, but tort claims, personal injury claims, and put real people, real polluters who are making money from destroying our environment in the box and hold them personally accountable. So that's my objective. And I fully agree with the previous speaker in his mission. We need that too. We need enforcement of all kinds of environmental law. So, I have to move to my next slide. There we go. Where do we start? We start really from the position of Friends of the Irish Environment in Ireland 2020. Successful case, but disappointing in terms of the environmental right in the Irish Constitution. Mr. Justice Clarke declined to decide that there was a right to a healthy environment, partly because he said it was a vague and ill-defined scope and concept, and it really was more something for political decision-making. So the aim of this presentation really is to say, are we there yet? Are we now there today in 2026? And I'm going to say, put my stake out there, that the right to a healthy environment is now well established in international law, particularly after the ICJ small states case in 2025. But what is the scope of that right, and how has that right been applied? And when I say what is the scope, you'll be aware from all the academic commentary, are we greening existing rights? Right to life, right to health. Is there a standalone right? And if there is a standalone right, is it ecocentric or anthropomorphic? And those are some of the questions that I will hopefully get to answer just before 10 o'clock. And I'll give a few examples of constitutions in the US where that has been applied. Now, I do apologise most sincerely to the audience due to the need to earn a crust as a self-employed barrister, and due to people scheduling things at the last minute, my case has been moved forward and I have to dash off just about 10 o'clock. But I do hope to get back later today. So my presentation sections really are recent important jurisprudence, emerging case from other jurisdictions, and other constitutions, structure and legal application. So moving on to the recent jurisprudence. So the three cases, you'll all be very familiar with them. Advisory Opinion Obligations of States on Climate Change 2025, International Court of Justice. The Klimasignorinen Schweiz 2024, European Court of Human Rights. And the Cana Vacciolo and others against Italy 2025. And we do have, I did notice on the programme, some Italian participants here. All very significant cases. So just a bit of a reminder, Obligations of States Rate Climate Change 2025, really quite a groundbreaking decision. And groundbreaking because the ICJ was asked to answer two questions and answer them with great thoroughness, with great scholarly erudition and searching for the evidence in international treaties and worldwide to ground its decisions, as you will see if you read that decision. And it said it had two questions to answer. What are states' international obligations to protect the environment, and what are the legal consequences if they fail to do so? And the court made a finding, it really is kind of a revolutionary finding, but they did back it up with all of the conventions that we are all familiar with. I haven't got time to mention them all this morning, but you'll all be aware of them. But they did say, the ICJ, it did say, and I appreciate it's just an advisory opinion, but they did say that the right to a healthy environment is now a binding norm of international law. Let's let that sink in, a binding norm of international law. I'm one step closer now to walking in to the High Court, Court of Appeal, Irish Supreme Court, and I know we have one of the judges of the High Court. He's not in this room, but he was here this morning. He's at the conference, Mr. Justice Humphreys. And I'm one step closer now to walking into that court and saying, this is applicable in Ireland. And the ICJ said that that right was derived from the corpus of international legal instruments, and that it was a precondition for the enjoyment of other human rights. And on question 2, the court said, what are the obligations on states? They said that states have a duty to prevent significant environmental harm, due diligence, that it had to abide by precautionary principles, and that there was a duty to cooperate with other states. And that leads us into the extraterritorial jurisdiction, which I'll come to hopefully at the end. The Klima Signorininen case, again, you'll be all familiar with that. But what did the court find there? It was fairly revolutionary for Europe. Now, those of you who are familiar with the Inter-American Court on Human Rights and African courts, you know, Europe is behind on this, really. But in any event, there's a greening, if you like, of human rights law. The European Court of Human Rights found Article 8, the right to private life, private and family life, includes a right to effective protection from the serious effects of climate change. And you will be aware, this is the Swiss Grannies case, a number of senior Swiss women brought a case to say that climate change was, and the heat and so on, was affecting them in a way which damaged their right and health. And Switzerland was found to have failed to comply with positive obligations. And interestingly, the court found that representative organisations had standing under Article 6 as the access to courts. They could claim victim status, although the individuals, in fact, could not in that particular case. And then another huge development, the Canna Vacciuolo, again, and others against Italy, 2025, and that's to do with the horrendous pollution and toxic waste in and around the Bay of Naples, which has gone unchecked. It's a long saga, and the judgment makes very interesting reading. But essentially, the efforts of Italy, for various political reasons and enforcement reasons, just did not deal with it. And the situation was such that American naval bases and naval-based personnel stationed in and around that bay were told to watch out for their health and to take various precautions because of the toxic dumps and the illegal waste and connections with organised crime. So that was an excellent case in that the European Court of Human Rights moved things on another portion and found that under Article 2, the right to life encompasses the right to protection from chronic environmental risks and pollution. Now, we do have then examples from other constitutions, and I've looked really at the US mostly because that's another common law country. It's one that we're familiar with in terms of its jurisprudence. And if we're talking about a right, a constitutional right, a codified right, one is looking in the Irish system to be able to reinterpret our constitution and our rights to move past that block of vague and undefined in Friends of the Irish Environment. So we can look at other constitutions in the US, and India, of course, is another. I've just chosen a few examples. Pennsylvania is one of the oldest ones. It introduced an environmental rights amendment in 1971, and that followed nearly a century of environmental exploitation by lumber and coal. People have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people. We've got something similar in the Irish Constitution, including generations to come. Now we're looking at the temporal scope of a right. And then as trustee of these resources, the Commonwealth shall conserve and maintain. There's been a series of cases, PEDF against State of Pennsylvania, but in the 2017 one, the Supreme Court of Pennsylvania, that is not of the United States, held that proceeds from the sale of public natural resources, including the sale of oil and gas from public lands, has to be considered part of a public trust. And Pennsylvania was not entitled to spend that revenue on general budgetary items. And Other litigation and other cases essentially decided that this particular ERA means that the people of Pennsylvania have these rights. Public natural resources are the common property of all Pennsylvanians, including future generations. So we're looking at the temporal scope of a right to a healthy environment. And all levels of branch in government are trustees, and that leans into Richard McCrory's previous idea that the governments have the responsibility and the audit bodies. We look at Montana, and again, that one has kind of hit the headlines a little bit more, perhaps, than Pennsylvania. Again, based on a constitutional right, Environmental Rights Amendment, 1972, during a wave of mainstream environmental concern in the US. And that provision came alongside all of the other constitutions in the states, Illinois, Pennsylvania, and Massachusetts. And the rights are set out there. Again, similar to the rights, and a defined right. My presentation, I'm sure, is available, so I'm just going to have to move on from that slide. And in that particular, one of the notable cases held against the state of Montana, the district court there ruled that the state had violated constitutional environmental protections by requiring regulators not to consider, so the regulators were asked not to consider it in their environmental impact assessments, it's GHG emissions or climate impacts on the Montana Environmental Policy Act. This would have been part of the sort of the rollback of recent rollback, and the state being directed, don't consider that when you're considering new oil and gas licenses. And held in Montana, this was contrary to the Constitution. And this was upheld by the Montana Supreme Court in December 2024, which is very hopeful. I think also, as a slight aside, when we look at all the public news coming from the US, we forget that there's a lot of very strong local action in states. New York Constitution also contains a right to a healthy environment. And in 2021, 70% of New Yorkers, look at that number again, 70% voted in 2021 to enshrine environmental rights in the New York Constitution's Bill of Rights. It's the newest environmental rights amendment in the US state. It's more simple, environmental rights. Each person shall have a right to clean air and water and a healthful environment. Now it does, it's not as strong as some of the others. It lacks required state enforcement or express authorization for the public to enforce the amendment. And in Fresh Air Against the East Side, in Clean Air case, the New York Supreme Court found that the ERA did not create independent substantive rights beyond existing law. But it doesn't say, and if you read into the case, it can be used as an interpretive aid to other substantive law. And then, obviously, there's a wealth of cases and decisions in India. I've referred to India particularly because those of you who are constitutional lawyers may know that the Constitution of India was based on the Constitution of Ireland, as they were great admirers of De Valera's 1937 Constitution. And in Friends of the Irish Environment, Indian constitutional jurisprudence was referred to the Irish Supreme Court, but the Irish Supreme Court said, well, we won't take note of that because their system is so different from ours. I think that's probably a little bit short-sighted as one of the major common law countries. But that constitution does have directive principles of state policy. That will probably ring a bell with Irish constitutional lawyers. But that there is an obligation of the state to protect and improve the environment and safeguard forests and wildlife. And then Article 51AG, fundamental duties. There is a duty of every citizen to protect and improve the natural environment. And then there is also a right to life. And one of the main cases here, Subhash Kumar against the state of Bihar, the Supreme Court recognized the right in 1991, that's over 30 odd years ago, the right to a pollution-free environment as part of the fundamental right to life under Article 21, and specifically affirms the right to enjoy pollution-free water and air as necessary for the full enjoyment of life. And it would have allowed Article 32 to be engaged, but it was protect fundamental rights, but the applicant was found to have ulterior personal motives. When I was looking at India, I could have chosen 15 or 20 cases in which the the Constitution has been relied upon. And interestingly, and this follows on again from Professor McCrory's work, the court in India does have this power to bring these kind of cases. I think it's called suo moto, or as does the Philippines indeed also. In fact, the judges have the power to initiate a complaint themselves. And there has been ongoing tensions in India about the funding of the court and the appointment of judges. And Professor McCrory is nodding there as well, because they have been quite activist. But nevertheless, it's a huge wealth of jurisprudence for us to look at and to walk into an Irish court to give us that ability to challenge the next time this Friends type case comes up, the next time to say, no, this right is not a vague and ill-defined right. So what should that environmental right be? So this comes to my, are we there yet? And having had a look at all of this, so my first question, if you like, and these are sort of the issues, should it be an embedded right in legislation or a standalone right in the Constitution? And this comes to, in this short talk this morning, I haven't had an opportunity to talk about the advantages and disadvantages of codification in general, and the advantages and disadvantages of codification for environmental law in particular. But I'll just advert to one. If the right to a healthy environment is enshrined in legislation or in the Constitution by a democratic process, either by referendum, obviously we'd have to do that for the Constitution, or by ministers and the Oireachtas, elected representatives, it does give an added political legitimacy. And if you go back and look at the original codifications of law, the Code Napoleon, Bundesgesetzbuch, a lot of these were dealing with the need to have a code to create a political unification and to have that sort of political authority for the laws that were there. And that is one huge advantage of something being codified as opposed to interpreted in the courts. We have a divisive political space, environmental rights. The scope of environmental rights is politically divisive. Judges are human beings. And it is of huge assistance to be able to say this is a democratically approved and codified right. So, if I say then, are we there yet? Major jurisprudence that we've seen in the ICJ and the European Court of Human Rights, I couldn't even begin to refer to, as I say, South America or Africa. But I don't think that there is any consensus at present that the right should be ecocentric. But I think there is, at least as a minimum, I think there is a consensus that a right can be anthropocentric. Now, whether that is greening of our existing human rights or a standalone environmental right to a healthy environment, I'm not quite sure at that from the jurisprudence, but at least I think we can say that, along with the International Court of Justice, the right to a healthy environment as a precondition for the enjoyment of all other rights is a binding norm in customary international law, and therefore I would be confident going into a court and arguing that the Irish Constitution is therefore required to be interpreted in that light. At least at that floor, we can build on the rest. What are the material scope or the substantive obligations? We would have to think of clean air, clean water, clean soil. These are the fundamental basics of the right, and we can see those across all of the other constitutions in the US and across. But I do think that is a minimum, and we still have a working out of what the rest of the substantive components are. And I was very influenced in a lot of my work over the years, and in fact the University of Aberdeen, when I was there many years ago, facilitated me to spend some time looking at German law. And Angela Merkel, at the time when she was Minister for the Environment, commissioned an Umweltgesetzbuch, and that was a huge cooperative effort to work out the corpus of environmental law, but also to look at what that substantive right, scope of that substantive right should be, based on the work of professors, jurists, litigators, etc. And that is work for us all here today, the three stools, the judiciary, the academics, the litigators, to spend some time perhaps and write articles and consolidate and flesh out in more detail the kind of material scope of a right, so that when the litigators go into court, that they're able to point to, which judges do look at, they are able to point to academic literature to say, this is what has been done and has been looked at. What are the procedural obligations? I think that's a little bit easier. I think we have the Aarhus Convention on access to justice, participation, right to environmental information, costs. I think we could scope that out. What is the personal right? Is it a right and duty only on states, but also on natural and legal persons? I would say that certainly the international jurisprudence clearly has to deal only with states. But if we look more generally, a constitutional right does give right to natural and legal persons. What is the temporal scope? I referred to a lot of the US constitutions talking about future generations. We have some domestic German legislation, German decisions on future generations. We have some other European countries on future generations. So I think certainly I would have scope for arguing if I went into court to say the Irish constitutional, if we interpret it as a right to a healthy environment, that must also include future generations. And the jurisdictional scope, again, I think that the ICJ, which situated this duty to cooperate, means that you're moving into an extraterritorial scope of that right. So, in my conclusion, are we there yet? I think we are there in terms of a core. I'm not sure we are there in terms of the penumbra, if one likes. But we have a lot of work to do, academic work, consideration work, so that the three stools can work together, so that one of these days I can walk into a court and have the Irish Supreme Court recognise the scope and parameters of the right to a healthy environment. So thank you so much.